Court's now in session, middle page 1, Crystal Rice versus Thomas Villarreal.
For the record, this matter is before the court this morning for the purpose of reviewing the defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Dwight Kuhn, representing the plaintiff mother, Crystal Rice. Good morning, Mr. Kuhn.
Good morning, Your Honor.
You're muted, Mr. Kuhn.
Yeah.
Oh, I'm informed you're not muted, but we just couldn't hear you. Maybe your volume. In any event, Mr. Rice is present with Mr. Kuhn. Is Thomas Villarreal Jr. present on audio?
Yes, sir. How you doing?
Good morning, Mr. Villarreal. The parties have conferred this morning with Mr. Walker from the front of the court, who has provided the court with the following recommendation, noting that the parties are currently on a waiting list with Family Counseling and Shelter Services, which Mr. Villarreal is frustrating to this court. And it's unfortunate we don't have another agency in this community that can offer therapeutic parenting time. But the fact of the matter is they have a waiting list. They're still on that waiting list. You should follow up with them, make phone calls to see where you are on that waiting list.
I will. I'll be
noted. It's noted that actually the first counseling session is actually May 5th. Sunday.
Your Honor, that is if I may, Dwight Kuhn, can you hear me?
Yes, we can now, Mr. Kuhn.
That counseling session is with a psychiatrist type counselor, not with Mr. Villarreal. That's child counseling that the court also ordered. Just to clarify.
Okay, thank you. So the Mr. Villarreal is on the waiting list with Family Counseling Shelter Services for therapeutic counseling. However, the minor child shall have his own counseling session on May 5th, Sunday of this week. It's recommended that the court order that child continue with such counseling. Both parties shall be civil if they see each other at the minor child's extracurricular activities. I mean, Con, you're both adults. You're parents of this child. You should be civil with each other. It should not have to be part of a court order, but it is. Further, it's recommended the court order that mother shall not interfere with father contacting the minor child by phone. And the party shall appear back for its court to review parenting time on August 6th, 2024 at 9:30 a.m. And if there's been no parenting time with the Family Counseling Shelter Services prior to that court date, either party can request an adjournment. The court's probably not inclined to adjourn this, Mr. Kuhn and Mr. Villarreal, because the court wants to reestablish relationship between dad and the child. So if the court fully expects, we'll review this matter on August 6th to at least explore alternatives. If there's no contact between dad and the child with therapeutic counseling. So that's the recommendation. Mr. Kuhn, is this recommendation agreeable with your client this morning?
Yes, everything except for I'm guessing we're not clear on what you meant by a modification on August 6th if the session doesn't happen with family counseling, with your family counseling services. We would oppose a change in parenting time without that supervised time having occurred.
Understand. And then nothing will be changed until we get input from mom. It's just the part of the recommendation says if there's been no parenting time with that agency prior to August 6th, either party can request an adjournment. So I don't want you to say now we want to adjourn that without any input from Mr. Villarreal. So I fully expect let's review it on August 6th. In fact, Mr. Walker, let's remove that sentence from this order. I want the parties to come back. Maybe there's some alternatives for the benefit of dad. So we'll review this on August 6th at 9:30. Maybe there's some alternatives. But obviously the court's concerned because this agency is such a significant backlog, and it's detrimental sometimes to children to be without meaningful contact with the other parent for so long. There are other cases in which there's months and months. So I don't want either side to there be a unilateral request for adjournment. Let's review it on August 6th at 9:30. So just delete that last sentence, Mr. Walker, if you could, please. It creates more confusion than the court wants everyone to appear on August 6th.
I can do
so,
that.
With that clarified, Mr. Kuhn, is this recommendation agree with your client?
Yes, Your Honor. We still have concerns with coming back because, as I explained to Mr. Walker, that this session is these sessions are occurring through no fault of my client, and yet my client is incurring expenses. Mr. Villarreal has incurred no expenses. And as previously was laid out, Mr. Villarreal created this circumstance.
I didn't create this circumstance.
So I guess if we have to come back, in 90 days without the session, we have to come back. The court has the ultimate decision, but I would ask that it be delayed even longer because those supervised parenting time sessions are important. The court is now in possession of the friend of the court's evaluation, which Your Honor ordered to be done by a interviewer from the friend of the court. That interview recommended that the sessions be reserved. So, I mean, everything is said no so far from the friend of the court staff. There shouldn't be any sessions with the child absent some supervised session. And I don't know what other options are available from Monroe Court other than the service that the court uses. And so we think that's important, and we would ask that this be delayed until those sessions are available. Even with the counseling, this child is a good student. He's an honor student at Wyandotte High School. He plays sports, and he's being made to go to counseling by court order to correct something that we're not even sure what exists. The child has an issue with dad, obviously, and there's a relationship issue there. But I don't know what the court expects the counselor is going to do. The court's heard testimony previously about the child being abused. And it might not be a legal definition, but emotionally, physically, verbally, the child doesn't want to be around his dad. He has two siblings that don't want to be around the same man. The court can order them to do it because they're both adults now. But my client, the child has his own cell phone. He's had his own cell phone. The child doesn't want to talk.
Mother controls the cell phone.
He can call.
All right. We're not going to argue right now, Mr. Villarreal. Mr. Kuhn, the court is very well aware of the circumstances. I fully appreciate your client's position. You had to come back and for you to incur your expense. But the reality is this court's obligation is to attempt to try to repair that relationship between dad and minor child.
Thank you.
Thomas can be gone before we know it, and he can do whatever he chooses. He can choose not to have any contact with his father, but while he's a minor, this court's obligation is to make every effort to try to reconcile and reestablish or restore that relationship between dad and child. And not to trying to punish the child by going to counseling, but hopefully maybe it'll assist him in working out some of the issues that, yes, were perhaps caused by his father. Were there any criminal charges ever authorized against the Mr. Villarreal, Mr. Kuhn, to your knowledge?
No, there were not, Your Honor.
Okay.
Nothing is rose to the level of a criminal offense.
All right. Well, thank you.
So
again, after the courts. Go ahead, Mr. Kuhn.
We will obviously abide by the court's recommendation.
And I understand Mom's frustration, but again, this court's obligation is to make every effort to try to establish a relationship in the short time frame we have here. But while Thomas is still a minor, I'm pleased to hear that he's doing well in school and engaged in extracurriculars and sports and so forth. Mr. Villarreal, do you understand the recommendation this morning?
Yes, Your Honor, I do.
Do you have any objection to the court adopting the recommendation?
No, I do not.
Do you know where you are in the waiting list? Have you called the agency to find out where you are in the list?
I've called, Your Honor, and I did not receive a call back. My phone was down for a couple weeks, but I will be on the call as soon as this meeting is adjourned.
Okay, and are you involved in any type of counseling, Mr. Villarreal?
Yeah, I'm in the counseling.
Okay. You should be to see what the counselor suggests and how you restore a relationship with your son.
Yeah, I'm working on situations and things that I might be able to do that will help out.
All right, right. The court's going to adopt the recommendation. We'll serve it back on August 6th at 9:30, and hopefully it can just be a very short session, Mr. Kuhn. But we'll at least get an update at that point in time.
Thank you, Your Honor.
Thank you, everyone. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Yeah.
Matter Crystal Rice versus Thomas Villarreal.
For the record, this matter is before the court this morning and to review defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Dwight Kuhn, representing plaintiff mother Crystal Rice. Ms. Rice appears to be present with Mr. Kuhn. Good morning, Mr. Kuhn.
Good morning, Your Honor.
Is Thomas Villarreal present on audio? Appears that Mr. Villarreal has not appeared this morning. This matter was scheduled for review at 9:30. It is now 9:55 a.m. Mr. Villarreal has not appeared. He's not contacted the court. Mr. Kuhn, have you heard from Mr. Villarreal this morning, or has your client?
We have not. Neither is my client, Your Honor.
And the court would note that this review hearing was scheduled back on April 30th. Mr. Villarreal was present at that time. Mr. Kuhn, has Mr. Villarreal had any supervised parenting time at Family Counseling Shelter Services? Do you know?
He has, Your Honor. The Family Counseling Shelter Services apparently produced a report of that parenting time. If the court would like, I can summarize what occurred during those visits relatively briefly.
Right, please. When was that last visit?
The last visit that occurred was on 7/11. In short, Your Honor, back on the first visit happened on 6/12. And at that visit, Mr. Villarreal told his son that he didn't really want to see him, that they could just talk by phone. The next visit happened on 6/19. He spent the entire time lecturing the child and had no real interaction with the child. On 6/26, the facility had an emergency. They canceled that visit and rescheduled it with Mr. Villarreal for 7/3. On 7/3, Mr. Villarreal did not show up. On 7/11, it had been moved to Thursdays from the previous Wednesdays. Dad came to the meeting, was there less than 5 minutes, and stormed out of the facility. The facility, because of his behavior, was going to terminate sessions going forward. But they were in the process of doing that. But something happened that I'm not aware of, haven't seen a report on. Something happened at the facility by Mr. Villarreal on or about 7/18. Mr. Villarreal apparently called the facility and made some kind of threat to them, so much so that the worker who had been supervising refused to be involved anymore with Mr. Villarreal. And the management had to get involved. Be that as it may, they did reschedule a hearing, or a parenting time session for Mr. Villarreal again, with his knowledge and timing. That was set for 7/25, and Mr. Villarreal did not show up. He has not showed up today. Mr. Villarreal was sent a schedule of the child's football scrimmages that are going on in the summer. Mr. Villarreal has not appeared for any of those. If you review the last court hearing, we talked about that. My client was advised not to do anything to discourage that. and she hasn't. This information was provided by the child at mom's request to Mr. Villarreal so that he could show up in the stands and watch his son play football. This child is now captain of his football team, is being currently scouted by colleges, has a tentative offer to what college?
University of Tennessee.
The University of Tennessee, Your Honor. Certainly this child is no slacker. And we're asking today that the court drop its prior requirement that the child have ongoing counseling. The child may continue in counseling anyhow, Your Honor, but it's one thing for the child and mom to decide the child continues in counseling. It's another matter for the court to order it. With Mr. Villarreal failing to appear today, failing to adequately participate in the court-ordered supervised parenting time sessions, we're asking that this matter be closed as of today and that no further action be scheduled by the court concerning the child or Mr. Villarreal until such time as Mr. Villarreal files something with the court requesting that and providing some explanation for his behavior and failure to appear. This case is costing my client money for me. It's cost my client money and time, losing a half a day or more of work for every one of these parenting time sessions to take the child there because she doesn't live in Monroe. And Mr. Villarreal obviously doesn't want to participate. So we're asking, Your Honor, that you would remove the counseling order and close this case unless Mr. Villarreal does something in the future.
Thank you, Mr. Kuhn. The court will follow the recommendation of Ms. Patrick. And at this time, defendant father's parenting time is reserved until he petitions the court. Court notes that the minor child is 16 years of age. And further, the minor child shall not be required to continue or attend counseling unless Thomas and his mother believe that would benefit Thomas. I'll leave that to Thomas and his mother. So no future review dates at this time. Hopefully, Mr. Villarreal will come around. Obviously, Thomas needs a relationship with his father, but at this point in time, the court will suspend his parenting time until he petitions court. So, Ms. Rice, the court would still suggest to the extent you can facilitate a relationship between Thomas and his father, you do that would be in the best interest of Thomas. But you can only do so much. I understand that.
Yeah.
All right. Anything further than this morning, Mr. Kuhn?
No, Your Honor.
Right. Thank you. That will conclude this hearing. You'll be mailed a copy of this order. Thank you, Ms. Patrick.
You're welcome.
Good luck, Ms. Rice.
Thank you.
Thank you.
I'm ready. I just wanted to give you a heads up. I had to move Brian into a separate room because he's extremely aggressive this morning and dropping F-bombs. So just so you're aware.
I've got him in my waiting room.
Yep, because I put him there because he popped out of the.
Yeah, I saw he popped out. Okay, I'll bring him in. On page 1, Amy Sobieski versus Brian Grace.
For the record, this matter is before the court on the plaintiff's motion to compel answers to interrogatories, as well as plaintiff's motion to modify child support and plaintiff's objection to a front of the court child support recommendation. This hearing is being conducted via Zoom. President Attorney John Danielski, representing the plaintiff's mother, Amy Sobieski. Ms. Sobieski is present. In addition, defendant father Brian Grace is also present. Good morning, everyone.
Good morning. Good morning.
Mr. Grace, the court was informed that you were acting inappropriately, using foul language when you met with Mr. Pratt. This court will not accept that. Do you understand that?
Yes, sir.
And if you cannot participate as an adult in a rational fashion, we'll give you the opportunity to be heard. If you cannot, then we're going to mute you. Do you understand that? That will not be tolerated. You should not
I understand. It's just it's hard. It's hard not to be emotional when we'll talk about it. I'm sorry. I apologize.
And if you cannot control yourself, then hire an attorney to talk on your behalf, Mr. Grace.
I have no money to hire an attorney. I have to give it all to her.
You're not giving it to her. You're supporting your children, Mr. Grace.
100%, sir. But I mean, if I
may, you can stop right there. You can stop right there, Mr. Grace. All right. The parties have conferred with Mr. Pratt this morning. The recommendation of Mr. Pratt is that modified child support enter commencing January 1st, 2024. Mr. Grace shall pay child support in the amount of $1,103 per month. Uninsured medical expenses shall be shared as follows: 10% by plaintiff mother, 90% by defendant father. It's based upon dad having 75 overnights. That's a recommendation. Mr. It's a pretty significant increase from the current support order of almost double the current support order. All right, Mr. Danielski, is this recommendation good with your client this morning?
Your Honor, my position on this, and keep in mind, the last child support order was quite a long time ago. I think it was quite a number of years ago. My position was, as I mentioned to Ms. LaPrade, if Mr. Grace wasn't going to object, I'm not going to object. At the end of the day, sure, I can live with it, Your Honor, but I'd like to make some comments because I think this is actually a very favorable recommendation to Mr. Grace. Mr. Grace had a previous employer. We have two girls here, by the way, Your Honor. They're with mom. Dad gets 52 overnights a year. Ms. LaPrade put him at 75 overnights a year. So she gave him 23 more overnights than he gets. He has every other weekend from Friday to Sunday. So that's one advantage on the rec for Mr. Grace. The second is he had a previous employer last year that I attached the personnel records where he walked off the job in insubordination at work, was basically doing at work what he was doing here today. If we continued with the income that he had at that previous employer, Ms. LaPrade could have put him at $96,886 per year. That's the income he was making there. In the child support formula, 2.01G says when a parent is voluntarily unemployed, the court should impute income. And that's what occurred here. He walked off the job, got in an argument with his supervisor, and Ms. LaPrade could have put him at approximately $97,000 a year, but she didn't. She put him at 48, and we'll live with it, Your Honor. But so that's another advantage to Mr. Grace. He's started a new job recently, January 29th of this year, and Ms. LaPrade looked at his income, prorated it for the year, and has put him at approximately $48,000 a year, which is what he has made so far this year. So it's a big benefit to him, what has occurred here. And then regarding my client, there's two girls. She also has a 2-year-old boy. She's a stay-at-home mom. Both girls have ADHD, anxiety, and some high maintenance things that require her to be there, along with the 2-year-old that she has. And the court can't impute income to her because if it did, the court would have to impute childcare, which would further increase Mr. Grace's support. That's 2.106G3. So overall, this is a very favorable recommendation. In my calculations, our support could be as high as $1,800 a month, Your Honor. So we'll live with it, Your Honor.
Right. Mr. Danielski, what about the motion to compel answers interrogatories?
I did get those. I believe they came in on Saturday. I saw them for the first time yesterday. And I did send those over to Ms. LaPrade, which had his current income. So I'm just missing that.
Okay, so that request has been addressed. Correct? The only issue this morning is child support.
Yeah. Yes. I'm dismissing the motion to compel. I believe that's what Your Honor is.
Yes. Yep. That's all right. All right, Mr. Grace. The interrogatories have been answered, so the only issue is the child support. Mother's motion to modify child support. It appears that the last order was entered. Not sure what year, but some time ago. So
I think it was 2018 year, but I think 2018, but I'm not sure. I know it's been a while.
Right. To Mr. Grace, do you understand the recommendation this morning?
I do.
Okay, your response.
Your Honor, all right. At FTech, I worked there for about 2 years. A lot of that income, sir, it was all overtime. I worked anywhere from 70 to 90 hours. I worked Saturdays and Sundays. They were mandatory. It was a union shop, and so it took me away from my children. I wasn't able to see them on the weekends. So I've had problems with the supervisor there for a very long time. I did everything I could, and finally he snapped and I snapped, and I walked out. I did clock out as leaving. We are a union shop. They did try to bring me back. We exchanged messages and stuff like that. After that, I did find a job, but I did file for a motion for child support because I lost my job and I was worried about getting way behind. So I filed the motion to get it lowered, and it was denied. So it stayed the same. So they filed for this. So here we are for this. But after then, I had got a job, and I continued, started making payments. I did everything I could to show up at court and stuff like that, so I didn't get behind. I see my kids every other weekend. I drive to Ohio, an hour and a half to pick them up. I meet the mother. I do things with my children. I understand the $1,000 is for the children. I get that, but it's to support the children. But if I can't support myself, how am I to support my children? I barely make $2,600 take home after I pay Amy and the courts and everything else. And now on top of it, I'm gonna have $1,100. My rent is $1,000. Like I just don't understand how, and that's why I got so upset. And I do apologize. But everything that's came out of her lawyer's mouth is to belittle me and make me look like I'm not a good father, and I am. She literally, she's an RN or an LPN, Your Honor, and she has not worked in 4 years, 3 years. I understand that she has another child, but that child is not my responsibility whatsoever. I take care of my 2 children, and I struggle doing it, but I do it. She's taken my kids from me to where I can't talk to them, so I had to file a motion. I filed the motion. I'm doing everything as a father. And it just keeps taking and taking and taking. She has a husband that she can rely on. I have nobody. I had me. And it's frustrating. So yes, I did get a little, my mouth gets the best of me sometimes, but I'm trying. And it went from $650. I'm paying $722 plus I pay $135. I have my kids on my insurance. So on top of that, it's going up almost double. And I barely make it as it is. So, I mean, I don't know what to do. I mean, obviously this is probably going to happen. I'm going to have to pay double, but I don't understand. Like, how am I supposed to support myself? You said that it's to support my children, but at the same time, I can't support them if they don't have a place to live when they come see me. I'm working now. I make $21 an hour. I work 48 hours a week, barely work any overtime. I drive an hour from my home. I drive 2 hours to go get my kids every other weekend. I didn't fight her on living in Ohio. I didn't fight her on none of that. But here I am. She's fighting me on everything. Everything from a woman that is wanting to support her kids but doesn't have a job. She's relying on her husband and my child support. It makes zero sense. I have no problem paying the $722 plus $135. That's what I feel that I should pay. And when my kids come, sir, we don't just sit at home. We go out to eat. We do things. We do activities. I buy them stuff. We have fun. And I'm not going to be able to do none of that. That's all, sir. That's all.
All right, Mr. Grace, there's no question. Of course, mind you're a good father. You're here today. You've been exercising your parenting time. That's not an issue in this court's opinion. And child support is based upon a formula, black and white formula, your income. My understanding, it's based upon your new income, not your former income, but your current income. Is that correct, Ms. Flagg? You ran these numbers on his current income, and it's about $48,000 a year.
I did, Your Honor.
And if
Sir,
in fact,
say something real quick.
If Ms. Obeski worked, then there'd be childcare costs, and that would be a part of the calculation. You have to contribute to those childcare costs. And sometimes the childcare costs are pretty significant.
I would rather pay the child to have, instead of her not working. We both should be working. So if I had to pay the child support or for the kids to be in daycare, then it is what it is. But at least I know she's working. But here I am, almost going double to pay a woman that doesn't even work. And I'm literally going to, sir, if I have to pay $1,100 a month, it will break me. It will destroy me. I will once again have to look for another job. And there goes me getting behind again because I can't make the payments. I'm going to literally have to find another job because I do not work enough overtime here to survive if this is the case. I just don't understand how it can double.
Well, because of the fact it's not been reviewed in so long. Mr. Pratt, if the court imputed that minimum wage to Ms. Sobeski how much difference would that make? Then, of course, we don't know what the childcare costs are.
Sir,
The court has the authority to impute
same.
minimum wage to her. Is that correct?
The court can do that, Your Honor, but again, yes, we could do that both ways. We could also make sure we imputed any childcare that we may assume. The problem that you're going to have is that it's likely to be more because the childcare will be higher if we were to impute an amount for her.
So who's the childcare for?
So that's the court's final analysis too, Mr. Grace. The childcare costs added in, even if we imputed minimum wage to her, you could be looking at more than $1,103. So this is based upon there's a child support formula set by the state of Michigan, and this is based upon the formula. So at this point in time, the court appreciates your position. I understand it. You can have an attorney review the figures. He can review all the calculations, and I think he will agree with this calculation. But this does not mean you're not a good father, Mr. Grace. Obviously, you're acting in your children's life.
How is someone? I mean, if you guys do the math, I make $840 a week. Okay, if you guys are taking $1,100 from me, how is anybody looking for support with me? Like, if I can't, I'm not going to be able to support my kids if I can't support myself. And Your Honor, I was making the same amount that I was making 4 years ago. So I don't understand how it's up more when I'm making less, because I was working. That's all overtime. Everything it was all overtime, and I'm working none.
And this calculation is based upon your current employment, not your former employment. It's based upon your current income.
I was making more at my former employment. You see what I'm saying? I was making more.
Your Honor,
calculation. Mr. Pratt, can you explain?
At the request of the court, if I put mom in at minimum wage and $800 a month in childcare, which is probably a low estimate, the support goes up to $1,504. Just so you're aware.
But who's the daycare for?
For the children.
They go to
mom's got to work. Somebody's got to watch the children.
They go to school and she has a husband. Okay.
Well, they need latchkey after school in the summertime.
There's two parents in the household.
Yeah.
So I mean, they're 11 and 7.
Yeah, it might be well worth it to invest in an attorney. Just have an attorney consult for this limited issue of child support. Have him run the figures if he knows the Michigan child support guidelines, Mr. Grace.
Well, why would you
rely upon the firm of the court?
This is what you guys ran, and it's 1103. Why would it change if I get a lawyer? That's just more money that I have to spend in the broker I get.
Because you can confirm with the lawyer that this is a very good recommendation. That's what you can confirm.
I already know I either go with 1103 or I get screwed at the 1500. So I'm in a win-lose situation. It just makes zero sense to me how somebody can sit at home and do nothing, do absolutely nothing, dress my kids like slobs, make them. It's horrible, man.
Right, Mr. Grace. Mr. Grace. Okay, Mr. Grace. Here's what we'll do. Let's give it. I'm going to put minimum wage to her, and we'll add in childcare costs. Mr. Pratt saying it's about $800. That's average. And
we'll keep it at the level.
$1,500, Mr. Grace. Do you want to keep arguing about this because it's going to go up? I can guarantee you that.
We'll keep it at the 1103. I mean, like I said, I'm not going to win, so it is what it is.
But you can talk to an attorney to say whether or not this is on base. I think the attorney will confirm with you that this is a reasonable and appropriate amount of child support. So the court's going to adopt the recommendation. That will conclude this hearing. You can both zoom out. If your income drops, Mr. Grace, you can always file a motion to modify and reduce your support obligation.
So, I mean, in all honesty, I'm better off quitting my job and saying I have no job. I mean, in all honesty, and working under the table like all these other deadbeat dads do. Sir, I'm not arguing with you, man, but you know what I'm saying? You got to hear me out. I have no lawyer to argue for me. So at the same time, and it's no disrespect to you, you've been nothing but awesome throughout this, but it's just ridiculous. I don't understand. I don't understand how a parent does not work, but here she is making what somebody would work part-time. It's ridiculous. But
Grace, I'm not going to keep repeating myself. Talk to an attorney. If we impute minimum wage to her, and I can do that, we're going to add in childcare costs. You're going to be paying more. Talk to the attorney. I think the attorney will confirm that with you.
I'm fine with the 1103. I'm not going to dig myself in a deeper hole, but it is what it is.
Okay. All right. The court will adopt the recommendation. I will conclude this hearing. You can both zoom out. Have a good rest of the day.
Thank you, Your Honor.
Welcome.
Sad, bro.
Can you close that? They want to drop that bomb on me and then they got to hold in contempt. Get rid of them.
Court is now in session, top of page 2, Tori Carrier versus Elena Hare.
For the record, this matter is before the court for the purpose of reviewing plaintiff father's parenting. Time this hearing is being conducted via Zoom. Present is Attorney James Petrangelo, representing the plaintiff father, Troy Carrier, and Attorney Lowry Rains, representing the defendant mother, Elena Hare. Good morning, Mr. Petrangelo, Mr. Rains, and Ms. Hare is present with Mr. Rains. Is Mr. Carrier present on audio this morning?
He is not present, Your Honor. I have called and gotten no answer, so I do not know why he is not here. I have requested an adjournment so that I can at least try to find out what's going on. And you have a recommendation from the front of the court to reduce parenting time at this time. I think nothing really new anybody is aware of since we were in court on March 13th. So I suppose, I have to, on my client's behalf, say I think to take away an entire weekend is extreme until I at least have a chance to get him in here.
Do we have any documentation that Mr. Carrier is currently engaged in anger management counseling?
We do not.
I'm sorry?
We do not, Your Honor. And if in the alternative, the court were to adopt this recommendation, I would request that it be added that I have the right to or opportunity to renotice this. I mean, of course, if he's doing nothing, I would be unlikely to renotice it. But if he has been and simply missed this date and went to work, I'm sure he would want me to bring that to your attention right away.
Thank you. Sure, that's a given. Certainly can renotice it. But Mr. Carrier was present on March 13th when this adjourned hearing date was scheduled.
That is correct.
So the recommendation of Ms. Patrick this morning is that plaintiff father should have a parenting time every other Sunday from 1 p.m. to 6 p.m. to be supervised by the maternal grandparents to do the transportation. And Mr. Petrangelo saying that was reduced from the prior order?
Yes, Your Honor. An order that was entered back in August provided that he have sometime on each weekend. It was alternating Fridays to Sundays and alternating Sundays from 9 a.m. to 6 p.m. So basically there was time every weekend. And that's been in place a long time. I know the court's well aware of this case and all the parties. Mom, well, she certainly has concerns that she's raised, acknowledges the grandparents have been picking up the children for the parenting time, and there is a relationship there as well. So I think to cut off so much of this is my concern.
All right. The court notes that. Thank you, Mr. Petrangelo. To refresh the court's memory, has Mr. Carrier been exercising that parenting time that he was previously awarded on a consistent basis?
My knowledge of Ms. Hare has indicated the grandparents are picking the children up as scheduled.
Right. Is dad present? Is dad present exercising his parenting time? It's not for the grandparents, but it's for dad. Has dad been there on a regular basis?
I can't tell you that, Your Honor. I haven't spoken to my client since.
All right. Since. That would seem to be the only basis for the court to reduce or modify parenting time. Mr. Rains, so what's Ms. Hare's understanding in terms of dad being present for this parenting time previously awarded?
My client did speak at the front of the court level earlier, Your Honor, and she has indicated she is not aware of him exercising his time. I appreciate that it would be hearsay, but she did offer that the children have related to her that their father has not been present during at least some of the time that he would be entitled to. So her understanding is he has not been present for some of that parenting time.
Thank you. Of course, the children are 11 and 9 and 6. They're certainly old enough to relate whether or not they saw their dad on each of those alternating weekends. Right. Ms. Patrick, if you could simply note on this recommendation that Mr. Carrier just may put next to his name FTA, they failed to appear just for the court's reference in the future that he did not appear today, but of course his attorney, Mr. Trandro, did appear. So at this point in time, the court's going to adopt the recommendation. The father's parenting time will be alternating Sundays 1 to 6, supervised by parental grandparents, and they will do the transportation. Mr. Trandro, this of course does not. This certainly allows your client to petition the court to renotice it for hearing to address parenting time.
Thank you, Your Honor. And in talking to Mr. Raines, I believe it's agreed that this can be exercised this Sunday to keep on a schedule the parties are familiar with.
That's correct. The 1 to 6 this Sunday. We're agreeable, Mr. Petrangelo.
That's noted. And also, Mr. Petrangelo, obviously, when we come back, the court's going to inquire about the status of his engagement in anger management counseling, which was previously ordered. So I think if he wants to renotice it, he should have some documentation in his back pocket.
I'm certainly would be unlikely to petition unless he has something, Your Honor.
All right.
Thank you.
Anything? All right, you're welcome. Anything further this morning, Mr. Petrangelo or Mr. Raines?
No.
Nothing further. Thank you, Your Honor.
All right. Thank you both. The court will adopt the recommendation. Thank you, Ms. Patrick.
You're welcome, Your Honor.
All right.
Thank you, Your Honor.
Court is now in session, bottom of page 2. Crystal Beck versus Anthony Letourneau.
For the record, this matter is before the court for adjourned hearing on the plaintiff Crystal Beck's objection to a referee recommended order of child support. This hearing is being conducted via Zoom. You, Crystal Beck?
Yes, sir.
Good morning. Is Anthony Letourneau present on audio?
Yes, Your Honor. Morning.
Good morning, Mr. Letourneau. The two of you have met with Ms. LaPrade this morning. Ms. LaPrade is recommending that the referee recommended order be adopted. If the court recalls, the recommended order of child support was 0. Is that correct, Ms. LaPrade?
That's correct, Your Honor.
It's alleged that Mr. Letourneau unable to work due to medical condition. Mr. Letourneau, are you now receiving Social Security?
No, not yet, Your Honor.
Do you have a hearing?
I got a lawyer for that, and everything's going through her.
But there's no hearing date scheduled?
No, not yet, Your Honor.
When you were last before the court back in April, or previously, the court ordered that you provide medical documentation to the front of the court that you're 100% medically disabled of any type of employment. Have you provided that documentation?
Yes, Your Honor.
Right, Mr. Pratt, have you received such a documentation that you can't even sit at a desk job, a clerk at a gas station? 100%.
We do have a letter from his physician stating due to his disabilities, he is unable to work.
Okay. Okay, do you understand all this, Ms. Beck?
I do, sir.
Mr. Letourneau, you're still facing a pending charge of felony non-support. Is that correct?
That's correct, Your Honor. Just had court last Friday on that.
Okay. Of course, so the arrearages, I think they're about $16,000. The court's action this morning will not affect those arrearages. You understand that? Mr. Letourneau, do you understand that?
Me, Your Honor?
Yes, do you understand you still all these arrearages?
Oh, yeah. Oh, absolutely.
And how do you intend to pay those?
Once I get my disability, Your Honor.
Well, how right now are you buying groceries? How are you paying utilities? Who's supporting you?
My groceries is through the state of Michigan. I got food stamps. I got insurance through the state of Michigan. And that's all I got.
Well, you may be a prison candidate, Mr. Letourneau. If you don't start paying toward these arrearages, you could be find some time in prison.
Oh, I know, Your Honor. I know.
Ms. Beck, you probably want to pay close attention to the pending felony charge and let the the judge know that he's not paying anything toward arrearages.
I am in contact with the Attorney General for their proceedings as well, Your Honor.
Yeah. Again, even though he's got a physician's letter, it seems to the court that Mr. Letourneau could do something. He's got a mind, he's got a voice, he can do something, even if it's a job on his computer. There's something he can do to secure some income. In any event, the court is inclined to follow Ms. LaPrad's recommendation. Anything further, Ms. Beck?
No, sir. She gave me the information I needed.
All right. Ms. Letourneau, any other questions?
No, Your Honor, I don't think so.
All right, court will adopt the recommendation. The child support will be at 0, but you still owe those arrearages.
Correct.
And the court would suggest you start paying something on that if you want to avoid a prison sentence.
I
All right, good
understand,
luck.
Your Honor.
That's it. That concludes here, and you can zoom out. Thank you, Mr. Bragg.
Thank you,
Mr.
Your
Pomeroy has been elevated to this court by Minoka in front of the court attorney Rebecca Hicks, who's present. This hearing is being conducted via Zoom. Mr. Pomeroy, obviously, we'll hear from Ms. Hicks, but you're brought before this court because obviously you're not complying with orders of this court regarding your child support obligation. Ms. Hicks, can you give the court information regarding Mr. Pomeroy?
Certainly, Your Honor. In this matter, there is a current monthly support obligation of $269 per month. The arrears balance are $9,781.52. The last payment received was November 14th of 2022. This case was elevated to my docket today following a hearing with referee Wes McKee on March 28th. At that time, he felt that it needed to be elevated to your docket to seek potential contempt. There was a hearing in November 30th of last year before the referee where it was adjourned so that the respondent can provide documentation of his long-term disability benefit he receives and make payments. We've not received any of that documentation. On that June 25th date, the referee adjourned it over to March 28th with an order for the respondent to pay $100 by February 28th and an additional $100 by March 28th. Neither of those payments were made, nor have we still received any documentation regarding any sort of disability benefit. And then finally, on March 28th, the referee elevated it to our docket today. And in this last month, we have not received any payments. We've not received any documentation from Mr. Pomeroy regarding this disability benefit or any of the other claims he's made regarding applications for Social Security and denials and things of that nature. So at this time, the friend of the court is asking for a finding of contempt against Mr. Pomeroy.
And thank you. Mr. Pomeroy has not filed any motions to reduce the support obligation. Is that correct?
The current support is a reduced amount, Your Honor. It was ordered following a referee hearing on November 28th of 2023. And he's not filed 1 cent.
All right, thank you. All right, Mr. Pomeroy, do you understand that you're being charged with civil contempt of court for failure to pay child support as ordered? Upon conviction, you could be ordered to serve up to 45 days in jail. Because there's a possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all of that, Mr. Pomeroy?
Yes, I do.
Are you asking for a court-appointed lawyer?
I can't afford a lawyer.
Are you asking for a court-appointed lawyer at public expense?
What is that? Sorry, I don't understand like public expense. I still have to pay them, right?
No. The court's going to, because there's a real good chance you're going to go to jail, Mr. Pomeroy, the court's going to appoint an attorney to represent you. And give me a cell phone number that the attorney can reach you at.
Yes.
Okay, the attorney will reach out to you. We're going to give this information. Attorney, I need to ask you a few questions to complete this form to qualify you for a court-appointed attorney. Are you currently employed?
No, I'm not currently employed. They let me go. I'm on disability. I just talked to
how much do you receive per month in disability?
$1,500. I just talked to Sun Life to try to get the disability so you guys have it. They will not release it to me. I have to sign a piece of paper for them to release it to you. You guys will have to call them to get that. They're not just going to give it to me. And I've been asking them for it like immediately.
All right, the court's confused. Did you receive $1,500 a month in disability?
$1,500 a month, and that's it. That's for me to
Okay.
pay my lot rent, my electric. I have my insurance on my truck and truck payment, everything like that. It leaves me time I pay everything to keep my electric and everything on to live off of. It leaves me with $100.
Right.
I just got the doctors to show I had open heart surgery, May of 19th of 2023. Sorry.
Okay.
Because
All right, that's good.
when I went.
Of course, Mr. Pomeroy, you've never provided proof of your disability to the front of the court. You ordered to do that. You've not done anything. Do you own any property of any value? Do you own an automobile, any boats, motorcycles?
I own a vehicle. I pay on a vehicle.
Okay, what year and what model?
A 2020 Silverado.
What about, do you own a home or a manufactured home?
Yes, I own my own home. I pay lot rent.
Okay, so it's a manufactured home?
Yes. And I pay electric.
Bank accounts?
I have a savings account. That's it. That's what that goes into.
How much is in your savings account?
My savings account is, I have like $5. It stays, you can't touch because I had it for so long. It stays in there. You can keep the account open. So my Sun Life check goes in there every month because it's direct deposit.
All right, thank you, Mr. Pomeroy. The court will grant your request for court-appointed attorney. The attorney will reach you by cell phone.
Is there a way, like, because I have papers, like I said, I have papers showing I had open heart surgery, and I had this, they found out there was more wrong with me, and they have the papers showing.
You can ask these questions of your attorney. Again, I've said it once, I'll say it a second time, and it'll be the last time. You were ordered by the front of the court to produce documentation, verification of your disability. You've never done that. So again, you can talk to your attorney about all these things, but the court's going to schedule us for hearing. What day this week, Ms. Hicks, would you suggest?
Could we do Thursday, Your Honor?
I'm sorry?
This Thursday?
Thursday?
This court I'm going to the Family Law Conference on Thursday up in Birmingham, American Academy of Matrimonial Lawyers.
Oh, that's right. I do have that down.
So perhaps on Monday, are you available on Monday?
Monday the 6th?
Correct.
Yes.
All right, so Mr. Pomeroy, the court's going to order you personally appear in the Judge Blanc's court, 4th floor of the Monroe County Courthouse on Monday. I'm going to give you some time. Monday, May 6th, 11:15 a.m.
What time?
11:15 a.m.
I have a doctor's appointment. It's a U of M doctor's appointment. I can't miss that.
What time?
That is at 9 o'clock, and it's a yearly thing, so they're doing all kinds of testing.
That appointment is on Monday, May 6th. Is that correct?
Yes, it's May 6th.
Okay. All right, we're going to have you appear then the following day, May 7th.
Okay.
May 7th. Write this down, May 7th, 2024, 11:15 a.m. You appear personally in Judge Blanc's court. Your attorney will appear via Zoom.
Okay.
And the court's going to suggest, you have arrears about $9,000. Court's is going to suggest that you reach out. This is where you reach out to family and friends. It's called the Family and Friends Plan. So reach out, see if you get to $1,000 together. If you can bring $1,000 or bring a toothbrush, Mr. Pomeroy.
So I got to bring $1,000 by May 7th, or bring a toothbrush.
Correct. That's correct. And if you if you can pay $1,000, it's going to apply 100% to your arrearages. 100%. None of it's going to your attorney fees or costs. It's all going to your arrearages. It's going to reduce it significantly. It's going to do you a favor because it's going to get you off the radar of the state attorney general, because the attorney general is going to charge you with felony non-sport when you have almost 10,000 arrearages. So if you $1,000, the court would adjourn the matter without any immediate jail. I'm just suggesting that, but you can talk to an attorney. Maybe the attorney's got some defense for you, or other alternative suggestion, Ms. Pomeroy. But reach out to family and friends. You got a good week to do that. So you need to appear personally. May 7th, that's Tuesday, 11:15 a.m. Bronx Court was on the 4th floor of the courthouse, and make that payment at the front of the court if you're able to do that before you come up here.
Okay.
Anything further, Ms. Hicks?
Nothing further on this matter. Thank you, Your Honor.
All right, Mr. Pomeroy, any questions?
No.
Okay, we'll see you Tuesday, May 7th, 11:15 in Bronx courtroom.
All right.
All right, you can zoom out. Have the rest of the day. Good morning, Ms. Hicks. Mr. Leiter.
Your Honor, good morning.
Mr. Pomeroy is appearing via Zoom this morning on possible contempt proceedings. Also present is Monroe County Front of the Court Attorney Rebecca Hicks and Court Appointed Attorney Timothy Leiter. Mr. Leiter, have you had a chance to discuss these proceedings with Mr. Pomeroy?
Your Honor, I have. I would say Mr. Pomeroy has been very good about contact and talking about this issue. I did have a chance to talk to Ms. Hicks ahead of time and conveyed to Mr. Pomeroy a potential plea agreement here. And he says he wishes to comply with that. So, Rebecca, if you don't mind, could you put that on the record for me, please?
Certainly, Your Honor. Mr. Pomeroy did make the suggested $1,000 payment. As a result, the front of the court is requesting that if he admits to a finding of contempt, we not ask for any immediate jail. We simply adjourn this matter over so that we can monitor that he continues making payments moving forward.
So you're asking the court make a finding of contempt, but simply reserve any imposition of sentence. Is that correct?
That is correct, Your Honor.
So Mr. Pomeroy provided proof of his alleged disability.
I do not have anything in the file, Your Honor.
Mr. Pomeroy, you were previously ordered to do that.
I emailed everything to the case, whatever the caseworker had. I even sent it to him, what all I have, to my lawyer.
You sent it to your friend of the court caseworker?
Yes.
Okay, she might have it in her email and has not uploaded it to OnBase to the front of the court file yet, Your Honor. I will follow up with her after hearing.
Who is your caseworker, Mr. Pomeroy?
I'm not 100% sure.
Well, you emailed her, so you should know.
Hold on, I got the paper. When I went in there, I'm not 100% sure what it was. I had my mom help me pull it up my case ID and sent it.
Right. Do you want to call the caseworker, Ms. Hicks, and see whether she's got that in their email, please?
I can do that. Let me mute myself, Your Honor.
He's been asked to do that a couple of times. I want to make sure we got the documentation regarding his alleged disability.
I sent a thing showing my bank statement where it says it gets in there at $1,500 every month. And I called Sun Life and they sent it to my caseworker to give me a thing for you guys to have. And I told them I need it ASAP, and I still have not got that. So when I did, I sent them a bank statement saying I get it when it gets direct deposit at my $1,500 from them, and it says right on there what it is.
Your Honor, I have an email with a Monroe Community Credit Union that statement attached that shows the deposit amount he receives from, is it Sun Life? Is that what it says?
Yeah.
And then just in the email, he states information, but that's the document that was provided, was a Monroe Community Credit Union statement of account.
Okay, and all it shows is a deposit from an insurance company.
It shows you a $1,500 deposit.
Okay. Mr. Pomeroy, you need to provide in front of the court with a medical documentation that you are disabled.
From my doctors?
Well, I mean, what did you provide to the insurance company? Obviously, if somebody's paying you $1,500 a month, they must have some documentation that you are somehow partially or totally disabled.
Yes, I have had sign a piece of paper so they can get the doctors to send all my medical records to them.
Okay.
I have called Sun Life and asked them for that, and they said they'll get back with me every couple, it would be 2 to 3 days with my caseworker. I have not got it. I have been calling since and still have not got it. That's what I provided.
What about calling your doctor, whoever certified you as being disabled?
I could call the surgeon, Dr. Awadi, to see if he can send the email to me, and then I can forward it to them.
Okay. Yeah, the front of the court needs some documentation that you are medically disabled. So, you anticipate receiving more than the $1,500 a month?
Huh?
Do you anticipate receiving an increased disability payment per month?
That's all I'm getting for the month. That's it.
Okay. You need to pay a good portion of that toward your child support.
I
file a motion to reduce your child support. Do you have arrears almost $10,000, Mr. Pomeroy?
Yes, I understand. I had to borrow that money because I don't get my disability check till the 10th of this month.
Well, you need to make a payment then on the 11th of every month.
What's the minimum I can do? Because
about $300 a month, I would think.
I will do it.
Mr. Pomeroy, if you don't make progress, the state attorney general is going to charge you with felony non-support. If felony charge, which you go to prison. When you get arrears close to $10,000, that's when you catch their attention.
Okay, I will do the $300 a month.
So I think minimum. And if necessary, file a motion to reduce your support. Don't sit on your hands.
Okay.
Mr. Leiter, are you still there?
Your Honor, I am.
Okay. All right. Mr. Pomeroy, is it, first of all, are you satisfied you received your right to legal counsel by conferring with the attorney Timothy Leiter?
Yes, I am.
You understand the recommendation is if you admit to contempt for not paying child support as ordered, the court would hold you in contempt and the court would hang 45 days over your head. You would hold the key to the jail. If you're not making progress toward these arrearages, then you could buy yourself some jail, but there'd be no immediate jail imposed today. Do you understand that?
Yes, I understand.
And you understand if you admit to contempt, there'll be no hearing, no testimony taken other than your own. Do you understand that?
Yes, I understand that.
All right, raise your right hand to be sworn, please. Mr. Pomeroy, do you admit and acknowledge you're obligated to pay support for the maintenance of children born to you and Amy Turner?
Yes.
You admit and acknowledge you have outstanding arrears in excess of $9,000?
Yes, I
Do you admit and acknowledge that, except for your recent $1,000 payment, you've not paid any child support since November of 2022?
Yes.
When did you start receiving the disability payment of $1,500 a month?
It was like middle of February, March of last year. I got a denial, then they had to do appeal, and then I got it.
So you've been receiving $1,500 a month for the past 12 months. You've not paid any of that toward your child support. Is that correct?
Yes, because I was in so far behind. I had to catch up on everything because it took so long to get.
Ms. Six, do you have any questions of Mr. Pomeroy?
I have no additional questions, Your Honor.
Thank you. Mr. Leiter, do you have any questions, Mr. Pomeroy?
Your Honor, I do not.
Well, based upon the acknowledgement, admission of Mr. Pomeroy, the court finds that he is obligated to pay child support for the maintenance of children or a child born to he and Amy Turner. Mr. Pomeroy acknowledges arrearages in excess of $9,000 and having not made a payment for over the past 12 months. Notwithstanding the fact he's had disability income of $1,500 a month. The lack of due diligence on the part of Mr. Pomeroy is the basis for contempt. This court will only find Mr. Pomeroy to be in contempt of court. But the court will follow the recommendation. Is there anything further then, Mr. Leiter?
No, nothing further. We do thank the court in Ms. Six.
Thank you, Mr. Leiter. Ms. Six, what do you suggest for a review date for Mr. Pomeroy?
July 9th at 8 a.m.
Right. Mr. Pomeroy, you ordered to serve 45 days in Montry County Jail, but the court will reserve that sentence. You hold the key to the jail. You ordered to appear before Ms. Six. You can appear via Zoom on July 9th, 8 a.m. for review. Make sure you appear on that date and time. You'll be mailed a notice with Ms. Hicks's Zoom ID number, and she just wants to monitor that you're paying the minimum of $300 a month.
Okay.
And be proactive. If you need to file a motion to reduce your support, if you had other obligations and you can't pay that $300 a month, then you should file a motion to reduce your support. Be proactive.
Yes, sir.
Any questions?
Nope.
Okay. All right. Thank you, Mr. Leiter. That will conclude this hearing. You can zoom out, Mr. Pomeroy. The
Thank you, Your Honor.
paid, that is forfeited toward the arrearages. All right. I guess that need to be, that was not a bond posted. That was a direct payment. So no
That's
need to
correct.
take action on that. All right. All right. You can zoom out, Mr. Pomeroy. Thank you, Mr. Leiter.
Thank you, Your Honor.
For the record, these matters are before the court at the request of Monroe County Court Attorney Rebecca Hicks, who's present via Zoom this morning. It appears we have both plaintiff mothers present, Cassandra Hoskins and Haley Brothers. Is Michael Montry present in audio?
Yes, I am, sir.
Right, Mr. Montry, could you please state your name and current mailing address for the record, please?
Michael Montry.
Mr. Montry, obviously you're elevated to this level because of the fact that presumably you're not compliant with orders of this court regarding child support. Ms. Hicks, can you provide court some basic information on both of these files, please?
Certainly, Your Honor. In the 2010 case, both of these cases are arrears only. However, they have felony non-support convictions in both of them as a term of his probation. And so what we have put into his order in our cases is the monthly amount. So in the 2010 case, he is supposed to be paying that at a rate of $336 per month. His current balance is $8,925.49. In the 2015 case, it is supposed to be being paid at the rate of $500 per month. The total arrears balance is $13,675.14. We were last here with Mr. Montry just 2 weeks ago, and he is the one who proposed a payment plan so that we didn't take him in front of you 2 weeks ago as we had intended to ask for sentencing, as he is previously found in contempt of court on both of these cases on May 6th of 2019. It is a first finding and it is a 28-day balance. In order for him to have not been elevated to the court today to request for additional sentencing, he needed to pay an additional $836 over what he has paid. So basically April support in both cases. And he has not done so. He met with Ms. Brower, had no additional plan to be able to do so. So at this time, we are requesting additional sentencing on his previous finding of contempt.
All right, Mr. Montry, do you understand all of that? You got 28 days behind your head, and you hold the key to that jail. Those 28 days.
Yeah, yes, Your Honor. I understand.
So what day this week are you currently employed?
Yes, I am currently employed. I did mention something to Ms. Brewer today. I actually had some pretty good news. I actually got hired in at a normal job to where I'm not self-employed. I've got transportation back and forth. Being so I don't have my license back yet or anything, which was really hard to find employment in the first place. I'm currently seeking mental health support too through Catholic Charities, which has probably been one of the main reasons why I've fell behind, so much far behind in child support. It's not like I'm not trying to pay my child support.
Mr. Montry, let's hold on. I've got a busy docket. You indicated you're going to pay $836 before today. What happened to that promise?
I thought I was going to have a job to where I was going to be able to pay it. They hired somebody else to do the job. I'm currently doing a job right now as we speak. And I do get paid from this job on this coming up Friday.
What time on Friday we get paid? The morning?
I believe it'll probably be around 2 or 3 o'clock in the afternoon by the time I finish my job.
All right, Mr. Montry, I'm in order you personally appear in this court on Monday, May 6th, 11:15. And I will tell you, bring the $836 or you can have lunch over at the jail.
You said Monday, May 6th at 11:15?
Correct. Personally appear, Bronx Court, fourth floor of the courthouse.
Yes, sir.
So you hold the key to the jail, as I've said. So you need to pay minimum $836. Ms. Hicks, are you still satisfied with that amount, or does he need to bring in something more than that?
That would be satisfactory, Your Honor. And then again, we would be monitoring another month's worth that he pays the $836. So because that would just be the first Monday into the month, I would be satisfied with that $836.
All right, we've got Ms. Hoskins and Ms. Brothers present. Ms. Hoskins, anything you want to add? I presume we heard everything.
Nope.
You can appear on Monday at 11:15 if you wish. You're not required to. Ms. Brothers, anything you want to add?
No.
Okay, you can appear likewise on May 6th, 11:15. Then either you can learn that he's paid something today that day, or you can waive as he goes to jail. All right, any other questions, Mr. Montry?
No, Your Honor.
All right, we'll see you Monday, 11:15, Bronx Court. Hopefully you can reach out to family and friends and borrow that $836 if you don't get paid on Friday, because otherwise we're gonna send you over for lunch over to the jail. I don't know how many days you'll do, but we're gonna serve some, so it's critical. Reach out to family and friends. Pay a minimum $836.
Yes,
see you on Monday then, 11:15 a.m. Okay, you can
Yes.
you can all zoom out.
Okay, thank you, Your Honor.
You're welcome.
Thank you, Judge. I'll prepare those orders.
Welcome. For the record, this matter is before the court for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. The present is plaintiff father Eric Vaught, and also defendant mother Crystal Vaught is also present. Good afternoon, both of you.
Good afternoon.
Good afternoon.
The two of you have conferred with Ms. Pratt from the front of the court this afternoon, who's provided the court the following recommendation. It does appear to modify some terms of prior agreements. The recommendation that follows should have parenting time every other weekend. Fridays at 6 p.m. until Sunday at 5 p.m. The parties would meet at the Pleasance off I-75, presumably at, not sure, there's a gas station there, number of cannabis operations, perhaps the gas station might be the best.
Yeah, we do the gas station, sir.
Yes.
The gas station with the Taco Bell there?
Yes.
Yes, Your Honor.
Okay, that's okay. So parties will meet there to exchange at Fridays at 6, Sundays at 5, alternate weekends until the Luna Pier construction is complete. I'll have 3 weeks of summer vacation with minor child, 1 week in June, 1 week in July, 1 week in August will be taken with Father's Weekend. It will not be the week prior to the beginning of school year.
Excuse me, sir.
Yes, that's recommendation.
On the Sunday, no, on the Sunday, I thought Eric and I agreed to 6 p.m. Was that correct, Eric? Not 5?
I thought it was 6 as well. I thought it was 6 to 6.
Yeah,
Okay.
I had it written down. I'm sorry. Did I?
Oh, it's okay. You guys had originally told me 5, so I just stayed consistent.
Oh.
I changed it to 6.
Yeah, it
That
was
the
changed
request.
to 5, but we had 6 before. I'm being honest.
Fine.
Yeah.
That might be easier to remember. Friday at 6 to Sunday at 6. So Mr. Pratt, we can modify that to make it Friday at 6 to Sunday at 6. You both agree to that.
Thank you, Your Honor.
Thank you.
And you both can agree upon which weeks in those months, correct?
Yes.
He has this weekend coming, sir, so we would just like to move it forward.
Wonderful. Okay. All right. Do either of you have any questions for the court?
No.
So it'll be effective this Friday, correct, sir? He'll get Friday at 6.
Well, do you both agree with that? You know what's best for your respective schedules and that of your
Yes,
child.
I'd love to have them.
Is that okay? It's okay, Eric?
Absolutely.
Definitely.
I mean,
Okay.
it's certainly okay with this court if the two of you as parents agree. So yeah, so they'll start to based on you're both on the same page, which is wonderful. And please communicate if there's sometimes, as you know, there's construction on 75. So if it's backed up, just to let the other text other person know you run a little bit late.
We've had to do that.
So please communicate.
Yes, sir.
All
Yes, sir. We've
right.
done
Do
that.
you any other questions for the court or for Mr. Brad?
No.
Okay, all right, let's start this weekend then, Friday at 6 to Sunday at 6, and the meeting at Pleasance at the gas station where the Taco Bell is. All right, there's no need for another review, so that's wonderful. If in fact problems exist, either side can petition the court for modification of this schedule, but hopefully it'll work. And
For
of course,
clarification, I'm
you can always
sorry.
agree upon other parenting time as you can agree. And this does not prohibit other parenting time. If dad wants to take his son to dinner or something, or during the week, especially there should be more flexibility during the summer. So we'll work together.
We've
Yes,
done
sir.
that in the past, sir, for birthdays and stuff. But I do have a quick question. In regards to the clarification, and I just forgot what it was. I apologize. Sorry, I just forgot. Oh, for the vacations, how much time in advance are we to give and provide to request the week for vacation?
Well, what do you both believe is reasonable?
Would you figure about 3 weeks, a month to let us know to make the appropriate arrangements?
I was thinking maybe a couple weeks.
Okay.
Because there's a lot of stuff that I don't know, like with my job, you know, sometimes I'm on overtime, sometimes I'm not,
Right.
you know? I mean, that's why I was thinking like maybe like a couple weeks, you know, notification would be better than like a month, because a lot of things can happen in a month.
Yeah.
A lot of things can happen overnight.
Well, the bottom line is you both got to agree upon that week. So obviously the more notice if possible, Mr. Vaught and Ms. Vaught, you need to understand there's sometimes where it's maybe out of his control, but ultimately it's got what the two of you agree upon.
Sure.
I would say 30 days, but then no less than at least 2 weeks. No less than that, but as soon as possible would be better, because
sure,
that way I can coordinate properly.
Okay.
We need to put that in writing, minimum of 2 weeks advance notice. Or is that hamstring Mr. Vaught?
I don't have a problem with the 2 weeks.
All right. We'll just try to minimize issues. We'll put in there that
I'll make it as early as possible.
Okay. We'll just say minimum. There'll be a minimum of 2 weeks notice provided of your intended week during those months.
Yes, Your Honor.
You can add one just sends at the end of that. Just fellow shall provide a minimum of 2 weeks advance notice of his intended parenting time.
Yes, sir.
And I presume you previously adopted Friends Court holiday schedule. For example, like Dad always had his Father's Day, Mother always had his Mother's Day, and so forth.
Yes.
Yes, definitely.
All right, we're going to just add 1 sentence, so minimum of 2 weeks advance notice. So as soon as you know your schedule, Mr. Vaught, your work schedule, provide that notice to Ms. Vaught. So
definitely
plan for it. All right, wonderful. The court applauds you for reaching your own agreement. It's wonderful. And the court will adopt that agreement. You will both be able to copy of this. And that will conclude this hearing. You can both zoom out. Have a good rest of the day.
All right, thank you, Your Honor.
Thank you, Ms. LaPred.
Thank
you,
you.
Ms. LaPred.
Bye-bye. Thank you.
Session, bottom of page 3, Margaret Smith versus Leino. Stump.
For the record, this matter is before the court for the purpose of reviewing parenting time with 1-year-old child of the parties. This hearing is being conducted via Zoom. President Attorney Ron Bruce representing the plaintiff mother, Margaret Smith. Ms. Smith, are you present on audio?
Yes, Your Honor.
All right, good afternoon. In addition, Attorney Christine Hills is present representing defendant father Lonnie Stump, and Mr. Stump is present. And the parties have conferred with Ms. Patrick from the front of the court, who has provided the court the fine recommendation that parenting time shall remain and continue as previously ordered. Parties shall continue to use app close. The parties shall appear back for his court to review parenting time August 28, 2024 at 1:30 p.m. Court recalls Dad's parenting time was alternating weekends, Friday at 5 to Tuesdays at 7:15 a.m. and alternating Wednesdays 6 p.m. to 7:15 p.m. Mr. Bruce, is this recommendation agreeable with your client this afternoon?
Yes, Judge.
Ms. Hills?
Yes, Your Honor.
All right. Have the parties completed the SMA program?
I believe my client has.
Believe so, Judge.
Is that correct, Mr. Stump?
That's correct. Yeah, I watched the videos and yep.
I did. Ms. Stump, did you complete the SMA program?
Yes, Your Honor.
Okay, good. All right, Mr. Bruce or Ms. Hills, you want to board your respective clients this afternoon?
No, Judge.
All right. All right. Very well. Court will adopt the recommendation. Ms. Sarah Backer on August 28th at 1:30.
All right. Thank you very much. Thanks, Mr.
For the record, this matter is before the court for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. President is Attorney Ron Bruce representing the plaintiff, Margaret Smith. Ms. Smith appears to be present. In addition, Attorney Christine Hills is present representing the defendant father, Lonnie Stump, and Mr. Stump is present. The parties have conferred this afternoon with the front of the court. Court has received the final recommendation that fathers shall have parenting time every other weekend, Fridays at 5 p.m. until Tuesday at 7:15 a.m. The parties shall use app close to communicate only regarding issues involving the minor child. And fathers shall have such other parenting time as parties can agree. If a significant other is to be in the presence of the minor child, the other party shall be informed, and the person's name and date of birth shall be shared, and there should be no posts on social media regarding this case or the custody of the child. That is a recommendation. Mr. Bruce, is this recommendation good with your client?
It is, Judge.
Thank you. Ms. Hills, is this recommendation good with your client?
It is, Your Honor.
Wonderful. Would you like the parties sworn if you wish to voir dire them regarding the recommendation?
Yes, please.
All right, Mr. Stump.
I
Ms.
did.
Smith, can you both please? Thank you. Ms. Hills, you're going to be with Mr. Stump, please?
Yes, Mr. Stump, would you state your name for the record, please?
Lonnie Aaron Stump.
You've heard this agreement that's been placed on the record by the court this afternoon?
Yes.
And is that the agreement we reached in conference with Ms. LaPrade from friend of the court?
Yes, ma'am.
And you understand entering into this agreement, you are forsaking an overnight of parenting time every other week in favor of agreed upon parenting time between you and mom?
Yes, ma'am.
You're willing to do that?
Yes.
Right? Do you have any questions about this agreement?
No.
Are you satisfied with my services?
Absolutely.
Thank you. And do you believe at this time that this agreement is in your daughter's best interest?
I do.
Thank you. Nothing further.
Thank you, Ms. Hills. Mr. Bruce, do you have any questions, Mr. Stump?
No, Judge.
Questions for Ms. Smith, please?
Ms. Smith, you also heard the agreement, correct?
Yes.
You believe it's in your child's best interest for the court to adopt that, correct?
Yes, I do.
And you're asking the court to enter that as a resolution of this matter today, right?
Yes, that's correct.
Nothing further, Judge.
Ms. Hills, do you have any questions of Ms. Smith?
I do not. Thank you.
The court would note that any other prior orders which are not inconsistent with this order will continue in full force and effect. For example, the parties will use the defendant mother's school district for the front of the court holiday schedule. That was previously ordered, so that will continue as an example. I believe that was only other thing the court wanted to point out. In any event, the court would like to thank Mr. Pratt for her assistance, as well as, of course, Attorney Sells and Bruce for helping facilitate a resolution. The court applaud you, Mr. Stump and Ms. Smith, for reaching your own agreement. You know what's best for your child better than anyone in this world. Be flexible with each other. Mom, if you got some issues, reach out and be a little. No reason why, if it works with your schedules, that dad can have more parenting time. This is the bare minimum. So make it good for each other and your child. All right, with that, the court finds the agreement between the best interest of my child. The court will accordingly adopt that agreement. All right, thank you all. That will conclude this hearing. You can all zoom out. Have the rest of the afternoon.
Thank you, Your Honor. We appreciate the courts and the parties' patience with us this afternoon as well, while Mr. Bruce and I were tied up in another court.
Not a problem, Ms. Hills.
Thank you.
Thank you.